Hi, moms and dads. Monica here. How are you? Thanks for your patience. We had some internet outages because we're in the middle of a major rainstorm. So I actually had to create like a little portable internet, which is pretty cool. This is called the Orbic, Orbick. So with this little thing, I could literally take my computer anywhere and get internet. It's really cool. And so I just went down to the basement, and this little room here is actually where I run my other business. I do women's fertility massage. So when COVID shut me down in March of last year, that's when I picked up the pace with this business, the best interest of the parent. And that's when I built out my digital course. So it was actually because of COVID that I made the digital course, the best interest of the parent. So COVID turned out to be a good thing for me. And then I was actually shut down for 3 months. I couldn't work. And then even now, like no one really wants to come because I have to force people to wear a mask, and I hate doing that. And so I, I don't really see people as much as I used to. So this is my office, my actual office. So we're going to be down here today, and it's much cooler. It's like 10 degrees cooler down here, which is really nice. And we have some questions today. Now, the topic today is I wrote something of the nature of if you say this thing to the judge, if you do this thing to the GAL, if you do this thing, if you basically own your role in your child's life as the sacred parent, the sacred parental role, if you defend your values, if you use your backbone in your case, you're going to look bad. They're all going to hate you. Everybody's going to laugh at you. And so that is kind of the thing that we're told to be subdued and be small so that other people could come in and run our case for us and extort us of money. And this branches a little bit to what I spoke about last week when I spoke about being selfish. If you do this thing, you're going to look selfish. And in this particular live stream, it's more like if you do anything, it's going to look bad to the judge. So here's what I'm going to tell you about that. Because we have a real life situation where a client reached out to me last week, or was it 2 weeks ago I spoke to her? I can't remember. I spoke to a client a couple weeks ago during a private session, and she indicated, let me just pull it up here because I wrote it down. She indicated that her son is being abused in the father's home. There's no plumbing, there's no proper plumbing, there's physical abuse, I believe. There's a lot of truancy, there's a lot of issues. And the family court, of course, put the child with dad, the unsafe home. And mom is down to 4 days a month with her son. So she's got the same schedule I do. And her attorney told her that if she reports the abuse to CPS, it's going to look bad. I said, great, I'm going to be addressing this on a future live stream. So today is that live stream. So in her particular case, she's being forced to bring up all the child abuse stuff to her family court attorney. So this is divorce court. Okay. Mommy and daddy don't like each other. They're fighting over custody, blah, blah, blah. And so the abuse issues are being funneled through this system instead of the actual system that is equipped to handle child abuse, which is law enforcement, child protective services. I don't like CPS. However, I will say to you all listening or watching, if you are dealing with CPS, I would much rather deal with CPS than family court any day. Okay. The problem with CPS, and the reason most parents are terrified of CPS, is because CPS has a heavier hand. They could do more damage in your family. They could literally implode your entire family overnight. Like they could. They act like the ants in The Handmaid's Tale. If you watch The Handmaid's Tale, so that's like CPS. They could just swing the bat and bad stuff happens. So, but here's the thing with CPS. If you know your rights with CPS, your rights also matter more. So you could push back harder against CPS. And I have seen so many times when parents stand in their power with CPS, that has a stronger punch. So yes, CPS is very powerful. CPS could do a lot of damage. But when the parent is empowered and they fight back, they tend to do more. They can make that matter more than if you're in the family court. Family court is just a free-for-all, whereas CPS has a lot of hurdles to overcome to interfere with your life. And I find that most CPS cases are opened up by consent. So the parent agrees to have the case opened. They're not actually agreeing to that, but by engaging with CPS, you're giving consent. So when a parent doesn't know their rights, CPS is very, very dangerous. When a parent knows their rights, CPS can't do a whole lot. They could come to your door, knock on your door, but they can't really do a whole lot. So in this particular case, so, like I said, this child is being mistreated and mom wants to report it to CPS, and her family law attorney is saying it's going to make you look bad to the judge. So here's the thing. And this is not legal advice, please, do your own research. This is just my interpretation of the law. When you bring up a child abuse claim to the law enforcement or child protection services, that court will take jurisdiction over your case, and predominate the family court. So look up your statutes just to make sure. Look up the jurisdictional rules in your state. In Connecticut, where I live, if the minute CPS steps in, they have control over everything. So you can't ping pong and go into family court and report abuse and then go into CPS court and report abuse and then have two different systems happening. We do see that frequently, but it's really not supposed to happen. So a lot of parents will go into family court. They'll get a guardian ad litem to investigate child abuse, which is like utterly ridiculous because these GALs do not have the tools and the know-how to understand child abuse. And then the parent will also go to CPS and do the exact same thing. So you literally have two different systems working at the same time to investigate child abuse. And so what happens if the GAL discovers that there's child abuse and CPS says there's not, or vice versa? Then what happens? That's when things get really confusing. So I encourage parents to not double dip. If you're going to do something about your child being abused, which I recommend, I recommend choosing the venue that is equipped to manage child abuse. That's their job. It's their job to keep people safe. And it's the police's job to keep the public safe. And if the police find out that you're in family court, I'm not a fan of telling the police that you have an open case. If you say something like, well, we have court next month, often the cops will get lazy and they'll say, well, just tell your judge that the child's being abused. So I would rather you not, again, this is not legal advice. Do what you think is right. But I'm not a fan of telling police officers that you're in court, or that you have a GAL, or that you have a lawyer, or that your child has a lawyer, or that the child's in therapy with court. Report that there's a crime happening and ask that they investigate that crime, and just keep it at that. You don't have to give the police oh, my child's in therapy, because the cop could just tell you go, have your son or daughter tell the therapist that they're being harmed. And then you're stuck. And then your child is just going to be left in harm's way again. And also, you should not have to pay for your child to be safe. So if you're paying $150 for your child to go to therapy, why are you paying for your child to report abuse when you could call 911 or whatever and have that reported for free and have that investigated for free? Because what's going to happen is if your child reports abuse to the therapist is going to call CPS, and it's just you could get it done faster. You could do both, but I really think that we need to start holding these police officers accountable and not get these officers off the hook for not doing their jobs. Police officers should not be telling parents to just take it up to the family court, because family court is a civil court. And if there's a crime happening in the other parent's home, if you know your child's being abused, that's a crime. Child abuse is not legal. So why are we having cops tell us, oh, when you go to court in 2 months, you could just report it then? Okay, so my child has to be abused for 2 months. What if your next door neighbor was hurting your child? Would they tell you to take it to family court? So why is it that when it's done by a family member, like the parent, why does that get to sit on ice? While if it was anybody else, there would be an immediate investigation. So I'm a huge fan of just putting all the criminal stuff into the hands of the police who are equipped to manage criminal activity, and keep the civil stuff I want Easter Sunday. Take that crap to family court. If you don't have equal rights to your child and you want to fix that, take that to family court. I would not take child abuse to a civil court ever. So anyway, so in this case with this mom, her family law attorney is telling her not to report child abuse to the CPS. And so what I would tell parents to do, and this is not legal advice, this is just what I would do. I would say, and the lawyer says that will make you look bad. So what I would respond with, if it were me, this is just what I would do. I would say, well, family court's not going to be managing this. So it's going to be the other court. It's going to be the Child Protective Services managing it. So if Child Protective Services wants to tell me I'm looking bad by reporting this, then let them tell me that I'm bad or I look bad. And that's the thing. Like, people will say, well, that's going to make you look bad. But what does looking bad look like? What does that look like? Are you going to be accused of parental alienation? That's very common, right? Especially when there's sexual abuse happening. It seems like sexual abuse and parental alienation, those are like peanut butter and jelly. And so if someone tells you, like, well, if you report sexual abuse, you're going to look bad. Well, great. Then let CPS tell me that I'm bad or I did something bad. I'd rather take it up with them instead of me having to hold my tongue and let my child be hurt to look good. Because looking good in these situations doesn't work either, because we can't protect our children. So we could look amazing. We could look freaking, we could look like Tina Turner in the courtroom, being all sassy and stuff and looking awesome. But like, does that help our children to look good? Right. So it's like, I'd rather look bad and do something about my child's safety than look good, whatever that looks like. Because great, I look good, but I don't have my son or daughter. I'm still the underclass parent. So that's looking good hasn't gotten me anything. So I would rather have CPS take up their beef with me. And then if they do, let's just say CPS says, look, you're a bad person. How dare you report this child abuse? Whatever they want to say, whatever bullshit they want to come up with. If CPS wants to have beef about me protecting my child, you can say, okay, great. I understand that you think that I'm wrong for doing this. So if you, this is just what I would do, guys, not legal advice. I would say, well, if you'd like to serve me with charges on top of this because I look bad, what does that even mean? Where's the legal, I would probably say to CPS, like, okay, great. Tell me where it's codified in the laws that me reporting abuse is bad. I want you to point to the law that says that me doing this and me looking bad is against the law. Is it against the law to look bad? Okay. Can I be charged with something by looking bad? And if so, please write out those charges. I want to know all about me looking bad. Okay. Mom or dad did this. You did that. I want a list of all the things I did bad, because you're telling me that you're giving me a hard time for reporting this crime, right? You're giving me a hard time for trying to keep my child safe. So I want you to spell out those charges. And of course, and again, this is just what I've seen. I find that when parents do that, CPS leaves them alone. they never see that list of charges. And so every time CPS tries to stick it to you for trying to protect your child, you can say, great, I understand that you're not happy that I reported this crime. Okay. And if you repeat it back to them. If they say, this looks suspicious, great, please write out those charges. I want to know specifically bullet points. I need a list of charges, and I need the law. I need you to tell me the statute that says if a parent does blah, 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 it's suspicious, and suspicious means blah, blah, blah in the law. Like, make them research the laws of why something looks suspicious, because feelings are not fact. and so someone having a feeling, is that a legal issue? And so don't be afraid of stirring up feelings in these people, because all this stuff is all feelings based. You look bad, that's suspicious, that doesn't look good. You look like you're not cooperating, you're looking combative, you look hostile. So like, they say stuff like this to the parent, the protective parent, right? You parents who've tried to keep your children safe, you've been told stuff like this. And so you could say, okay, I want that spelled out. I want a list of charges. If you think that I'm bad, show me. I need the law, and I need the list of charges. So this is not legal advice. You could just ignore them also if you want, or you could freak out and try to get them to. This is what most parents do. They go, no, I'm good. Come look at my house. Come research my medical history. Talk to my neighbors. Talk to my boss. Talk to my significant other. I'm a good person. I'm a good person. Please. And then the parent just throws themselves at CPS and volunteers for like this long evaluation on the protective parent. and then that creates a lot of problems, because usually that protective parent is put into a case plan and just led through a series of hoop jumping and just a mess. So by really putting your feet in the ground and being like, no, I'm doing right by my child. And if you think I'm doing something wrong, I need that spelled out. I need the laws that show that this is wrong, or whatever you think it is. And so by by setting your foot down, you could show them that you're not someone to be messed with. So that's just what I would do. That is the approach I would absolutely take in a heartbeat. And I am not one to keep child abuse quiet. I won't sit back and do nothing because I'm afraid of looking bad. I don't care if I look bad. Looking good has gotten nothing for a lot of parents. I've never seen a parent, I think a handful of times. Often I'll see this when the kids are in foster care. But in divorce court, I've never seen a parent say, oh, I finally got my kids back. I was so agreeable. I agreed to everything. I did this, I did that, and I got my kids back. I've never seen that happen in family court. Like I said, the only time I've seen a parent kiss ass and agree to everything is when the kids are in foster care. And if the kids, once the kids are already taken and put into foster care, I have seen parents get their kids back for doing that. So if your kids are in foster care, that's obviously a whole different animal. I'm talking about when kids are actually in your care. So that I want to talk about. And then there's one more piece I want to bring up about this particular client I met with a couple weeks ago. So again, looking bad and like being suspicious and like having someone getting upset because you made a report of child abuse or acting a certain way, and like, for example, saying, I want a list of charges. I want you to show me the law that says that me reporting child abuse is wrong. What section of the law book says that if a parent reports child abuse, they can be subject to blah, blah, blah. Like by doing that and compelling CPS or the court or your lawyer or something to basically do their jobs and show you laws that say that looking bad or looking suspicious is punishable. Often just doing that will stir up something in them. They'll get mad at you and then they'll tell you that that looks bad also. So, and so what I'm going to tell you is that the Constitution protects you and it's your best weapon in the court system. And the Constitution would support you, holding your ground and compelling the other side to produce their evidence that looking bad is a problem. It's up to them to show that you acting the way you're acting is punishable and actionable. And it's not your job to give them a good reason why you want to report child abuse. Because parents do that. They're like, well, I'm reporting child abuse because child abuse historically has caused a lot of mental problems in children. And here's all the reasons why child abuse is bad. And here's all the reasons why I'm reporting it. You don't have to freaking justify why you're reporting child abuse. You don't have to justify that. You make the other side justify why you reporting it is wrong, and make them show you in the laws that it's wrong, and make them show you that stirring up an emotional response in somebody else is punishable. Okay, last I heard, hurting CPS's feelings and making them mad is not illegal. So your constitutional rights are your best weapon in court. And so when you stand your ground early on, you have the opportunity to have a winnable appeal. Appeals are really, 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 really hard to win. And so when you stand your ground early in your case, you have a better chance of appealing because you're not giving up consent. You're not giving away any rights. You're not, what's that word I'm looking for? Consenting. I think I said that word already. So no, you're not waiving your, I can't think of the word. You're not waiving jurisdiction. That's not what I'm trying to say. Never mind. It will come back to me. So, yeah. So, and again, I can't stress this enough. Get an attorney that will defend your constitutional rights in court. So that's what I would like to say. Let's see. So let's see. Someone says here, so we're going to be getting to ADA accommodations next. We have a parent saying, I filed ADA accommodations, was denied all accommodations by the judge, filed a formal federal complaint, and it was denied without any further investigation. They stated they were too busy. Holy shit. I'll have to get back to you on that one. So someone says, did you have an attorney? This is the parent. So it wasn't my case. This was a parent that I worked with a couple weeks ago, and she does have an attorney. So we have another, sorry, there's just some comments coming in. I want to make sure I get to all of them. So there's another piece of this. There's another thing I want to address in this live stream tonight. So I had another parent reach out to me, and this is interesting because last night's live got canceled at the last minute because Summer O'Brien wasn't available. And also we had a lot of storms, so it kind of was just not meant to be. So she's coming back on Tuesday. So this opened up an opportunity for me to address this. So we have another parent that took my ADA workshop. And hang on one second, let me just pull up his questions. So this gentleman here took my ADA workshop like a year ago or so, and he filed for accommodations. So let me just pull up his questions. There's some stuff happening. And I said I would get to that tonight. So, okay. So this gentleman says, I took your workshop. In court, I was accused. So I hate that word accused so much. I'm not saying that you made up that word, but I hate that stuff like this is considered an accusation. I was accused of mental instability, depression, and PTSD. So having a condition is not punishable by the law. Okay. You can't be punished for having a condition. You can't be punished for having diabetes. You can't be punished for having scoliosis, freaking bunions, hair loss, skin rashes, and not mental instability, depression. Okay. Excuse me. You can't, so that's not punishable. Okay. And it's not actionable. So I am a huge fan of opening your big freaking mouth in court. I don't care. I mean, again, not legal advice. This is just what I would do. When that crap starts happening on the other side, and I get really angry about this. Okay. I was an ADA advocate in the family courts on and off for 5 years. And I get really, really angry about this kind of crap because whenever there's a mental condition, the other side treats it as though the parent drove drunk with the kids. They treat it as though it were child abuse or whatever, irresponsible parenting. So this is just what I would do. I would say, I would object. I would cut right in, even if the judge told me to shut up. I would cut and say, excuse me, am I being charged with being mentally am I being charged with parental unfitness? Am I being charged? Can I have a list of charges? The other side is saying I'm mentally unstable. Please, I need a list of charges because the implication is that I'm not a good parent and hurting my children is against the law. So often the other side will be like, well, no, there's just a tendency to lean towards mistreatment of the child. It's like, but you could cut in and say, well, if I'm not being presented with a list of charges, I would like to strike that testimony. That's what I would say. I'm not an attorney, but you cannot be punished by the government for having a condition. You are automatically protected by the American with Disabilities Act just by virtue of somebody believing that you have any sort of mental instability, anxiety, depression, paranoia, schizophrenia, borderline personality disorder, even narcissism. If you're being accused of being a narcissist, I would say, am I being charged with something? Can I please see a list of charges? You can ask for a list of charges. The judge will not want to do that because they're lazy. The other attorney probably won't do that either. Because I believe to do a list of charges, I think they would probably have to get law enforcement or CPS involved. And nobody wants to do that because they don't want to punt the jurisdiction into another court because then they lose money. Because when other entities are managing this, it's paid for by taxpayers. So I would flat out just say, I need a list of charges. The judge would probably say, there is no list of charges, like the judge will try to make you shut up, basically, from what I've seen. This is just based on what I've seen, as an ADA advocate. And then I would say, well, then I would like to strike all testimony. I don't want any of that testimony in the record at all, because if I'm not going to be presented with a list of charges, then I don't want this to even be discussed in this court. And if the judge says, well, I want to hear what the other side is, I want to hear anyway. I want to hear this anyway, because judges love dirt. Okay. They're like little schoolgirls in the cafeteria. They love to hear the dirt. They love to hear freaking gossip. They love to hear people running their mouths. They love these accusations. They love all this stuff. Okay. They feed off of it. They're like breastfeeding off of this stuff. And so what I would say, again, not legal advice. This is just what I would say. I would say, well, Your Honor, this is prejudicial. This testimony is prejudicial because with the court having so much discretion, the court gets to use their own opinions on whether or not I get to parent my child. And if the other side is feeding the court, telling the court that I'm mentally unstable, that's very prejudicial. And with respect, Your Honor, I have legal protections. I have federally protected rights under the American with Disabilities Act. So if I'm being regarded as somebody who has a disability, then I want those protections. I would like the court right now, today, right here, right now, to implement legal protections on me right now under the regarded as clause of the American with Disabilities Act. And again, I know it sounds like I'm giving legal advice, but there's no other attorneys doing this. We don't have family law attorneys doing this. And a lot of civil rights attorneys won't do family law cases. So we are kind of blocked from that market because the attorneys that care about this stuff won't come into family court. And then the attorneys that do deal with family court don't like to practice real law. They're family law attorneys. They don't do nothing. And so I almost feel like it's my civic duty to tell you guys this stuff. And all this stuff is in a book. You get it for $40. It's called Unlocking Justice. It's by Karen Huffer. Okay. I get really angry about this stuff. Like I get so pissed talking about this. So there's a book called Unlocking Justice. You could get it on Amazon for $40. If you have a hearing coming up, the parent that reached out to me, you said that you have a hearing in August, get that book, read it, and learn from it and use that to defend yourself. Because what happens is the other side will say, oh, they have mental illness, they have this, they have that. And they do it to contaminate the judge's opinion of you. And so notice how I'm not telling you to prove that you're not mentally ill, because parents will do that. They'll be like, oh my God, give me a psych eval. Here's all my therapy records. This therapist says I'm great. I had a parent 2 weeks ago. She had to submit therapy records to the family court judge showing that she didn't have a mental illness because she was accused of having mental illness. And she did that simply because she was accused. So one thing I really hate is when I see parents spend 2 years in therapy because some idiot was running their mouth in court without charges, without presenting charges, without any American with Disabilities Act protections. And then the judge got prejudiced, took the kid away from the parent being accused. And then the parent who lost the kid puts themselves in therapy just to show 2 years worth of records that the parent doesn't have a mental illness. So why should you be locked into a 2-year hoop jumping thing because someone was running their mouth? Why not put the burden on them? And that's what I would do. I would say, I need a list of charges. They're not going to produce them because they're lazy. And also having a mental illness, that's not actionable. And so they can't prove it unless they have a copy of a therapist report saying that you're mentally ill, which they probably don't have. And even if you do, you can't be punished for having a condition. You are protected under the American with Disabilities Act. So you could box them in. Let me make sure I got all the questions. That gets to your first question, because you said I was accused of having, mental illness, blah, blah, blah. So I'm trying to get ADA accommodations for my next court hearing. Good. Get those accommodations, because you're entitled to those accommodations because you have been perceived as having a disability. So you automatically are guaranteed those protections. I don't have time to get into the actual accommodations. You'll want to take my workshop for that. The parent who reached out already has my workshop. So other parents who are watching, I encourage you to get my ADA workshop. I could put the link in the description when I'm done. So it says, I'm trying to get ADA accommodations for my next court hearing, but the judge says it needs to be more specific. Okay. So yeah, so I guess I have to get a little bit specific with the actual protections. So most parents, I'd say 99% of parents, if not 100%, I qualify for ADA protections in the court, because if you have situational anxiety, if you step into court and you get scared, right? You feel sick, you get nauseous, you get heart palpitations, you start to sweat, you get the lump in your throat, your voice is quiet, your voice doesn't carry, and you can't think on your feet. You're kind of a mess up here cognitively. If any of those things apply, then you get to have protections, because you can have temporary symptoms. you could have a temporary impairment and still get protections. So 2 years ago, I was on vacation in South Dakota and I sprained my ankle. I sprained my ankle on day 4 of my trip. So I was hobbling around like crazy for like 3 days. Day 7, I'm flying back home. I had my 1-year-old and my 12-year-old. Okay. And I was able to get a wheelchair all the way from the front doors of the airport all the way to the runway of my plane. And then when I landed in Hartford, I got a wheelchair from the freaking runway all the way to the baggage claim. I got a wheelchair ride, okay, in 2 different airports in 2 different states. Now, that was a temporary ailment. I sprained my ankle. I was fine in 2 weeks. I still got to have full protections. Nobody gives a crap how long you've had the impairment. What if I just sprained my ankle 3 hours before I had to be at the airport? Do I not get protections because I wasn't born with a damaged ankle? So you can have a temporary impairment that starts when you park your car at the courthouse and that ends when you leave the courthouse. If you have a temporary impairment for 3 hours when you're in court, you still get protections under the American with Disabilities Act. You can either take my workshop, which is $27, or you could get Dr. Huffer's book, Unlocking Justice. I suggest doing both. I suggest getting her book. You absolutely want that book. She's amazing. So you have the right to have accommodations in the court if you have any sort of temporary impairment. So the question is, how do I legally request accommodations? So what you want to do is you want to call your courthouse and contact the ADA coordinator. And you want to say, I have temporary impairments, or, I have impairments that prevent me from fully accessing the full experience of being in court. So, again, you're going to want to take the workshop or get Unlocking Justice to really get deeper into this, because I don't have a ton of time. But you want to request accommodations there. So think of all the things that you can do, that you can get in court, that will help you with your anxiety, that will help you with your heart palpitations, the lump in your throat, all the physical symptoms that you have. Think of all the things that could help you alleviate those symptoms. You can have an advocate with you to help take notes. That's what I would do when I was with my clients. I did a lot of stuff. You can ask for frequent breaks. If you have cognitive impairments and you can't take good notes while the other person's speaking because they talk too fast and you're not all here, you can request that the meeting be recorded. Often you have to supply the hearing. You could request that the hearing be recorded. And often you might have to supply the equipment for that because they're not mandated to cover the expense. So if you want to bring in your iPhone, you can ask to record the hearing. From there, often they will say no because you can alter the record, but you're gonna have to get into Unlocking Justice and or my workshop to get deeper into this stuff. But the parent that requested accommodations, he sent me his form and they weren't specific, so the judge said no. So here's another really important thing. It is not up to the judge to decide whether or not you get accommodations. It is absolutely not up to the judge, and the reason for that is because the act of granting accommodations is a clerical duty, and it's not a judicial duty. It's a function. It's an administrative function of the court. It's not up to the judge because you don't want the judge inserting his own discretion. You don't want the judge to use judicial discretion whether or not you get to have accommodations, because the judges don't get to use discretion on a federal mandate. Okay, so the federal laws demand that you get accommodations if you need them. And so you do not want to ask the judge for accommodations. You don't file a motion. You do everything through the ADA coordinator. If the ADA coordinator says, well, I'm going to go talk to the judge, says no, I would say, no, this is not a judicial function. This is an administrative function. This is dealt with the clerks. This is a clerical administrative function. This is a function that is dealt with in the executive, portion of the courthouse, not the judicial portion. That's very important. Sometimes the clerk will say, well, I'm going to go talk to the judge anyway. But again, get it in writing. Get everything in writing. Email and say, I just want you to know that I don't want the judge to use their own discretion on whether or not I get accommodations. So just make a record. Make your paper trail, okay? These people freaking violate the law all the time. You want a paper trail of you trying to make people not break the law. And so and so this is good for you. Parents often won't do anything. They'll say, well, they break all the laws anyway, I'm not even going to try. But you want to create you want to lead them. You want to build, just set it up so that they break the law. Does that make sense? Like, set things up so that they have to like overtly break the law. So what you want to do is like email the clerk and say, this is a clerical function. If you speak to the judge is inserting their own discretion. And it's also prejudicial because that's the same judge that gets to decide if I get to see my child or not. So you want to put that shit in writing. I mean, seriously, you could type it out and have it stamped at the courthouse, put it in your file, do what you got to do. Talk to an attorney about how to preserve this portion of your record. This is so important. So anyway, the parent that filed for the accommodations said that they want it recorded. Hang on. Let me see what the accommodation request was. So it says, what accommodation do you need in court? And the parent wrote transcription/recording. So there already should be a stenographer that you don't have to pay for. It's automatic for everybody. So I would find out if there's a stenographer typing, writing transcripts. I mean, there should be a transcript person already doing this. And then it says recording. So what I would have done in your situation when you were asking for accommodations, I would have said, I would like to bring a recording device so that I could record the hearing so that I can recall the facts and recall the sequence of events in the case properly so that I can get help with, so I can get the help that I need to keep my records. So I would have been more specific about, so if you're going to be specific about what you need, not on your condition. Does that make sense? So if they say, well, I need more details, that doesn't mean that you have to pour out your life story. There are parents who write out their accommodations. Parents will call me up and be like, I need an ADA advocate. I'm like, okay, great. And they'll show me their accommodations request and they literally attach like their psych eval. And I'm like, okay, now you're just giving away all of your privacy, your medical privacy. So you don't have to reveal your condition, but do be specific on the accommodations you need. So you have your condition, which is whatever you have, confusion, anxiety, whatever. And then you have the thing that you need. Focus on what you need, not why you need it. Okay. Why you need it doesn't matter. When I was at the airport and I said, I need a wheelchair, I sprained my ankle, I didn't have to explain why I sprained my ankle. If I sprained my ankle because I was at a frat party, doing jello shots off of strippers' belly buttons, and I slipped and fell on the ping pong table, and that was really stupid and irresponsible, I'm not less entitled to accommodations because I was stupid about it. So what parents are doing a lot is that they feel like they have to be innocently needing accommodations. Like they think that, parents will say, well, I have PTSD because my ex abused me. You could have PTSD because you suck at life and you never took care of your health, and you're still entitled to accommodations, So you could be irresponsible. You could have, it's like people who smoke. Like, are you less entitled to medical care because you chose to smoke? No, everybody gets treated the same in the hospital, hopefully, whether you got lung cancer from secondhand smoke or firsthand smoke. So don't feel like you have to use a discretionary thing when you make your accommodation requests. And you don't have to explain your disability. Another parent says, do I have to reveal what my disability is? Holy shit. If a freaking judge asked me what my disability was, I would say, I am not sharing that information, period. And it's not up to the judge to even pull that information out of you. It's the other side's job to pull information out of you. It's the other side's job to put you on the stand and get you to speak and get you to talk. It's not the judge's job to pull evidence from the parties. I don't understand why judges do that. Judges do that all the time. I think that's horrible. They're not supposed to do that. But again, you see that all the time in court. I mean, every time I've been to court, I've had to answer questions to the judge. The only things the judge should be asking is like clarification on your last name. How do you spell that? Clarification, like more clarification, but they shouldn't be pulling out new facts. I'm freaking going off on a tangent here. So anyway, the parent says, I want a recording. I would be more specific about the recording. I would not talk about your condition because that's nobody's business, ever. And so another question that was asked of this parent was, why do you need this accommodation to assist you? The parent said to process information, which is good. That's actually really good. I would have been more specific. I would have said, the recording will help me recollect the facts better. The recording is necessary because I can't take notes very quickly. That's perfectly fine. And most parents can't. I can't write down stuff. I mean, that's just crazy. It's easier to record stuff. I mean, I record these live streams, right? I mean, what if you guys had to freaking scribble all this stuff down that I'm sharing with you? It's so you could just be really simple about it. Be like, oh, it's easier for me to have a recording because it helps me recollect things better, and I can't write very fast. And then so the other thing the parent says, it's my ADA right, and that's really that's it's true. That is your ADA right, but I think that was more. I mean, I think parents could say that. They could say like, I think that's fine. I think parents could say, I have rights under the American with Disabilities Act to request this information. So I think the parent did fine, but it is okay to be more specific when they're asking questions. So let's see what we have for questions here in this live stream. So I hope I got to all of your questions, the parent that reached out. So we have a parent here that says, once I apply, I'm good until, do I need to restate for every hearing? Since I was denied the first time, how do I proceed in the future? That's a really good question. Personally, I would send in the same request for every single hearing. You want to cover all your bases. You want to just overprotect yourself rather than just submit it once. Because what if Judge so-and-so rotates out and then like Mr. Potato Head comes in and they don't understand your case and they don't bother to read your file? So I would continue to overprotect yourself, file for accommodations for every single, and your needs might change. Like you might have gotten temporary orders that are very debilitating, and so you need more protection. Or maybe this attorney is really triggering you. Maybe this attorney, when I was in court in 2010, my son's father's attorney put me on the stand and made me reveal all like a whole bunch of like sexual things I did in college and in high school. Like, how old were you when you lost your virginity? And he made me recant details about my high school sexual experiences. And I was 31 at the time. And so that was incredibly traumatizing to me. And I didn't know back then that I had the right to freaking tell him to stop. I didn't even know that I had the right to not answer those questions. I thought I had to say everything because I'm in court and like my ex doesn't like me anymore and I might lose my child. So I have to answer all these invasive questions. But what I should have done, if in retrospect, what I would have done was I would have, so again, if someone's triggering you in your case, and on day one, and they start bringing up your bad childhood and like bad things that you did, mistakes. I don't believe there's bad things ever that we do. We make mistakes, but they're all learning experiences. But if they start bringing up like your past transgressions or something, you might find that you're triggered. And so on day 2 of your trial, you might want more accommodations. You might want an advocate with you. If you've been a victim of assault or something and they start exploiting that, because that's another thing. If a parent was ever raped or assaulted or abused, they will be exploited for that. Okay. It's horrible. And you might want to bring in like a victim advocate with you as part of your accommodation request. And I absolutely think people should do that. Take advantage of all of those things. Take advantage of everything in the world when it comes to the ADA. All of them. Overprotect yourself. Bring in more accommodations than you think you need. Ask for more accommodations than you think you need. And and this is another thing I do. I've done this for clients. When I fill out their own ADA request, when I request accommodations, I put in there that this isn't punishable, that the parent can't be punished for needing support through the ADA, that the judge can't abuse their discretion and punish a parent for needing accommodations. I put that in there. I know I probably sound like an asshole when I do that, but I don't care. I'm so sick of parents getting beat up in court. I get like, this is a really hot topic for me. Like I actually had to quit ADA advocacy because I get too emotional. So then I start needing accommodations and that's just weird. Yeah. So someone says, let's see here. these comments. Oh my God. Look bad. How do you appear? How you appear in the judge's eyes, you'll bias the judge against you. It was opposite for me in family court. This is a good point. Who cares how you look to the judge when the child's safety is at stake? Yes. And is looking bad to a judge actionable? Is that punishable? Can you get punished for that? And where in the law does it say that you could get punished? And so when I write motions, this is back when I was in court a lot. I would say stuff like, I have rights, or plaintiff has rights to her child, even if the family court trier of fact decides that they don't like her or something like that. Like, I would put that in there, because you don't have to be liked to keep your rights to your child. So, so someone says, let's see, I missed that question. No, I got that one. Let's see here. So someone says, I had to do that too because I was accused. They're treating mental illness like it's a crime. I want to see a single person who's ever been arrested for having a mental illness. Once I apply, okay, so someone already asked, I already answered that. The court can't ask what your disability is. They can only ask what accommodations you're requesting. Yes. And if they do ask, I would not answer. Not because you have anything to hide, but because you don't want the judge using their discretion against you. My God, my hair is so frizzing because like the heat is so bad. I'm like, ugh, it looks terrible. I'm not even wearing makeup or anything. You guys are so patient with me. Our county does not have a stenographer. Okay, so if that's the case, then how do you keep a record? Okay, so the parent that says our county does not have a stenographer, are you sure about that? Because the courts are supposed to be transparent. So if you can't get a record, then how does a parent keep a record? Like, what if you have to appeal your case? How do you show, like, how do you build a record? How do you preserve a record if there's no stenographer? And what are the courts doing to ensure that these are transparent courts if there's no stenographer? And that, what you're saying here is reason why you should bring your own recording device. So someone says, I requested all those things. They were all denied. Holy crap. Oh my God, this makes me so mad. They can't do that. So Dr. Huffer's book talks about what to do. My workshop talks about what to do. You can file a complaint. And these things take 2 years to process. And it's like, okay, my child's 13. I got denied disability protections. I lost my child because of it. I'm going to go complain. It's going to take 2 years for that complaint to process. And let's just say the complaint goes well. I win. Yay. Then what? I get a new trial. So my child will be 15, and then that new trial lasts another year. And my child will then be 16. And then what? So it's still a freaking no-win situation. And the state knows that. So the reason why we are in a severely disadvantaged position, and I think I said this last week, maybe, I don't know. I remember I was saying this to somebody. The problem with our group is that we have a narrow window on when we can do things. So once our kids age out, we no longer have standing to fight because we don't have, whereas someone with black skin who's being discriminated against, they're going to be black their whole lives. And so if you're a person of color and you're discriminated against when you're like 20 and you need 10 years to gather your resources and your mental, to get the clarity needed to fight back and sue somebody, and you're still in a position where you can collect damages. I don't know. I'm getting mad. So is there a code or law section that states where a court can't ask? So not that I know of, but I know that's a really good question. So this is a case in your situation. This is where I believe it's worth paying 30 minutes for a civil rights attorney's time. If they charge $500, pay $250 to be like, can I get 30 minutes of your time? I just need to ask you some questions. And I'm not endorsing this, but again, if you're paying big bucks for stuff, I'm a huge fan of recording the call. I didn't say that. Okay. You didn't hear that from me. So, but I'm just saying you could. I'm not saying I do that. I'm not saying you should do that, but in theory, a person could record it because you want to remember what they're saying. Is there a code or law section that states where a court can't ask? So we do have the Fourth Amendment where the government can't pull private information out of you without a warrant. So you could use that. You could say, well, the Fourth Amendment protects me from being, from being what's that word I'm looking for? The Fourth Amendment protects me from the government invading my privacy and trying to extract information out of me that they could punish me for later. So you're securing your papers, effects. What's it called? It's late. It's hot outside. What is it called with the Fourth Amendment? Persons, papers, and effects, or something like that. So you're protected there. You also have rights under. You also have medical privacy rights. It's not HIPAA. HIPAA only protects your doctor from sharing your information. But you can say that you'd rather not share because the court has so much discretion, and you don't want to say something that's going to make the court think that they can take your kid away because of what you shared. You don't want to invite error into your case by by revealing information that the court can use to take your kid away from you. So search and seizure, yeah. So you're protected from your something, papers, and effects. Property, papers, and effects, that's not it. It will come to me later. It's really hot. It's 93 degrees outside, and my hair's frizzing, so I can't think straight. A record... County is broke. Clerk takes notes. It's sparse at best. I was denied recording device. Oh my God. Where the F do you live? Do you live in like West Virginia or something? God, that's really, really bad. That's horrifying. So another parent says, look up disability rights group in your state. Yes, that's a brilliant idea. That's a brilliant idea. You can maybe talk to someone there and say, what law protects me from being asked about my disability? I think just saying you can't ask is enough because family courts don't operate on real laws. So I always tell parents, like, why do you need to cite a law to protect yourself when no one needs to cite laws to take your kids away except for best interest of the child? So anyway, let's see if I got to everything. Plumas County, Northern California. Holy crap. California is a freaking blue state. You would think they would have all those resources. So, oh my gosh. Someone says the judge discussed my ADA request in open court, and he said he needed more information. Where there were people in the gallery. Was that wrong of him? Yes. I mean, when he says I need more information, he might not have been talking about your actual disability. He might have said he needs more information on the accommodations. So I would like to give him benefit of the doubt. It's possible that that's what he was referring to. So I would hope. All right. Yeah, the ADA is a very murky area. The laws are clear, but the implementation of those laws are murky. But that's why parents like us have to use these rights, because otherwise they're useless. The Constitution is useless. We don't want the Constitution to become obsolete. So we need to use our constitutional rights. I'm like laughing so bad because like my hair is just frizzing. Great. So I'm so glad you guys came on. So next week we're gonna have Summer O'Brien come on, and we're talking about a really, really fascinating topic. And I don't want to give it away, but it's gonna be super fun. You guys definitely want to come on to that live stream. So that's next Tuesday, 8:30 p.m. So I'm so glad you guys all came on. I appreciate you, and we will meet up on Tuesday. Okay. Have a good night. Bye-bye.